Richard Lewis is a partner at the firm Hosfeld, where he leads the firm's mass torts and environmental threats practice groups. And among his practice highlights, he has recently concluded a settlement in South Africa to recover compensation for tens of thousands of South African gold miners who suffered occupational lung disease. And in the United States, he has been appointed as counsel or co-lead counsel in several mass torts and product liability class action cases, as well as unsafe working conditions and unsafe drugs, and has litigated individual and class childhood lead poisoning cases. So at this point, please help me welcome Rick Lewis.
Good afternoon, everybody. I've never had to follow talk like that, and it's great to be here and to be among people doing all this important work. And I also want to say that in the early 1980s, I was studying chemistry and biology so I could do work on environmental health, and I was at the University of Buffalo. And there was a speaker at the law school that night named Ralph Nader. And chemistry and physics were very challenging for me. I preferred English and social studies. And I didn't know if I could take a few hours to leave my homework on chemistry and go listen to this guy, Ralph Nader, at the law school. But I did go. And I think I remember, that was the early 1980s, I think I remember everything that he said that night. And he has really helped me figure out how I could go on a path to try and do some good with consumers and environmental problems. So I'm going to talk about tort law and public health. And the name of my little talk here, I wrote some notes, is Tort Law and Public Health, a Difficult Relationship. And looking at all the victories in the Tort Museum this morning, that's not going to be my thesis here. Because my experience doing this for 30 years is that the legal system is not working very well on public health problems. And I'm talking about opioids. I'm talking about hormone therapy and breast cancer. I'm talking about the mass marketing of drugs and medical devices and their impacts on people. And I'm talking about groups of people, communities of people. And I'm talking about environmental exposures to toxic chemicals in the workplace and in the community, where we're not talking about one person. We're talking about groups, all the citizens in a community, or all the citizens of the planet, because we now have the climate change cases to talk about. And I would say that in this area, the law is doing less than we need it to do if the law is going to be an important tool to prevent these problems and provide remedies when they occur. Mr. Nader's Corvair case is very important and very famous. But I would say, unfortunately, that when I am in front of judges and talking to other lawyers, I find that the way they look at tort law is based on car accidents. You know, one car went through the red light and hit another car. And when we start wanting to talk about the latent effects of chemicals that occur 20 years after exposure and affect groups of people, that model doesn't work very well and has really hurt us in our ability to present evidence and present these kind of cases. So I want to talk about a couple doctrines or legal tools that are very important for dealing with these community public health problems or even global public health problems, and how they've been used and how successful or unsuccessful they've been, and how they might be more successful for us in the future. And those two tools are the class action rule, Federal Rule Civil Procedure 23, and a doctrine of law, a tort doctrine called public nuisance. Let me start with public nuisance. I see my first boss in the audience, Tony Roisman, and we worked on childhood lead poisoning together. And I'd like to talk about childhood lead poisoning as an example of the public nuisance doctrine. So I think most people know about childhood lead paint poisoning. Lead is one of the most well-studied toxic agents on the planet. It's been well understood for 50 years. It causes brain damage in the developing brain of a child, if a child is exposed to lead. And the effects are very severe at very, very low doses. Very well understood problem. The main way that children, particularly poor children, in the United States were exposed to lead is through chipping and peeling and disintegrating lead paint in housing that wasn't in particularly good shape. All right, so the paint was applied before 1950 in the first half of the century, but as it starts to get worn down on doors and windows, it creates really an invisible dust. Children, as we all know, are very active with hand-to-mouth activity, and that is the way that hundreds of thousands of children in any given generation were being poisoned by lead paint. So several governmental entities, states, cities, mayors, wanted to do something about lead paint. And they brought cases under the doctrine of public nuisance to try and fix the problem, to try and abate the problem. And they brought those cases against the lead paint industry because the theory of the case was that these companies knew that their paint was dangerous and continued to promote it for use in housing, particularly the interior of housing, with full knowledge that it was poisoning children. That was the theory of the case. So let's take a look at how the courts have dealt with this particular problem. And there are successes and there are failures. Let me start with the successes. 2 states, Wisconsin and California, have found that the state or the public entity can use the theory of public nuisance to go after this problem and try and get an order to abate all these lead paint housing problems to protect children. And the fund, the money to pay for that, would come from the major lead paint manufacturers, National Lead, Sherwin-Williams, etc. I was involved in a case in Wisconsin for the city of Milwaukee where we advanced this theory. And the trial judge threw our case out of court and said, you need to go house by house and prove whose paint it is and whose fault it is. You can't just say there's 40,000 dilapidated houses in Milwaukee and expect National Lead to fund the abatement. We're not going to allow that. Threw the case out of court. We appealed to the intermediate level court in Wisconsin, and the trial judge was reversed. And the appellate court said, importantly, that if a party generates or contributes to the generation of a nuisance, they can be held liable. And did not require home-by-home proof, allowed us to use aggregate proof about the volume of lead paint that particular companies were marketing in this part of the country. Unfortunately, we tried that case to a jury and we lost. We got to the jury. The jury said that it was a public nuisance. The first question they were asked, is it a public nuisance? Is it being lead paint in housing? Answer, yes. Second question, is National Lead at fault? No. That was the answer of the jury in that case. And when I got to talk to the jury afterwards and try to understand what happened, the most coherent explanation I got is, we used to live in that community and it wasn't a problem. We used to live in those neighborhoods and it wasn't a problem. Why should it be a problem now? If it is, it's the problem of the homeowner, the landowner, the tenant, somebody like that, not National Lead. In California, the case was tried on behalf of 8 counties before a judge in 2012, and the counties were successful. They won the case to create a substantial fund to abate the lead paint in the high-risk housing in 8 communities. And that's been upheld at the highest level of appellate authority in the state of California. In 4 other jurisdictions, the state of New Jersey, the state of Rhode Island, the city of St. Louis, and the city of Chicago, this theory has been rejected when applied to the identical problem, childhood lead paint poisoning and abatement of housing. And I want to just take a minute to talk about the reasons those courts used to reject the theory. And for those of you who are attorneys in the room, you know that when a judge is going to throw you out, he or she will find every conceivable reason and line them up. And I have a list of 9 reasons why those cases were thrown out. But I think the most important one is this concept of a public right. Public nuisance doctrine is based on the protection of things called public rights. And the health and safety of a community is well recognized as a public right. There were early public nuisance cases about slaughterhouses and chicken processing that recognized the community has a right not to be subjected to this stench, and found that the slaughterhouse was a violation of a public right because it affected the health of the community. But the courts that have rejected lead paint nuisance cases say that it doesn't involve a public right. It involves the interior of residences. That's a private property issue. That's a home maintenance issue. It's not an issue that involves a public right. And that was really kind of the kiss of death for this theory, according to those courts. They had a few other reasons that they mentioned. National Lead is no longer in control of the nuisance. They sold the paint 75 years ago, so they can't fix the nuisance. And since you want the nuisance fixed and they can't fix it, this legal framework doesn't work. Of course, the Wisconsin and California courts said, no, they don't have to control it, they just have to cause it. Let somebody else fix it with their money. But other courts have said, no, that doesn't work in the area of public nuisance. As I said, some courts said if you can't prove house by house whose paint it was and what they did wrong, you can't use an aggregate proof. You can't use a collective proof to proceed. Other courts said public nuisance isn't about products. Lead paint is a product, so you have to use a different law, the product liability law. And other courts have said, not only is it a product, it was a legal product. It was lawfully sold, and there can't be a public nuisance for a legal product. So that's one example of a very important doctrine, public nuisance, and how courts have dealt with it in the environmental setting. There is some promise that this doctrine will be useful in the future. It's being used in the opioid litigation. There was a trial in Oklahoma against all the opioid manufacturers that was successful. The state brought 1 count in public nuisance and was able to succeed on that theory. It's also about to be tried again in a bellwether opioid case in Ohio. It's also been pled in the climate change litigation. So several cities have sued the biggest oil companies in the world over climate change damages. A city like San Francisco or New York is basically saying, we are spending millions of dollars to deal with the effects of climate change, violent storms, health problems, different effects of climate change. We want to be reimbursed by the oil industry who had this knowledge and covered it up for 20 or 30 years while they continued to increase fossil fuel production, which has led to climate change. 2 judges have thrown that theory out. one in New York and one in San Francisco, on the merits. 7 judges have remanded the case back to state court to proceed as a public nuisance case. And there have been, unfortunately, stays in most of those cases until an appellate court decides on the remand. But I guess the bottom line is that public nuisance is a viable doctrine. It has potential to be used to get at these collective problems. Another success in that area was the MTBE in gasoline, which got into our drinking water. And the city of New York and the state of New Hampshire have used that theory successfully to collect an abatement fund against the manufacturers of the gasoline. And once again, they did this on the basis of aggregate proofs. If you have to go gasoline tank by gasoline tank or water filter by water filter, these cases are impossible. So they have to find a legal approach that allows the state or even the private plaintiff to aggregate their evidence and look at the manufacturers, in the case of MTBE, the manufacturers of the gasoline, and hold them liable. And what's important in the MTBE case is that it's not a dumper case. If you have to go after dumper by dumper, site by site, these environmental problems are too big. The case was pled against the manufacturer of the gasoline. No matter who drove it in the truck, who spilled it from the tank, or who didn't maintain the tank properly, the liability was against, right at the beginning, the manufacturer and distribution of the product. And that was the MTBE case. So I want to talk about the one other tool that I mentioned, the class action rule, which unfortunately I would say has had much less success than the limited success of the public nuisance doctrine in dealing with public health problems. Fundamentally, the courts in this country about 25 years ago, around the time when I got my first job with Tony, said you can't use the class action rule for personal injury, period. You can't use it. So here we have the one device that's out there to collect injuries when there's a public health problem, the one procedural device. And the court said you can't use it, period. And you can't use it in Agent Orange for soldiers in Vietnam. You can't use it in breast cancer for women in hormone replacement therapy. You can't use it for asbestos. This is how it first arose in the courts, for the tens of thousands of workers who were exposed to asbestos and suffered lung disease. And the reasoning was everybody's disease process is so unique and so different that a court just simply cannot deal with this as a collective wrong and try a case. And that's pretty much well accepted. Those of us who work in this area have no choice but to accept it, and it's been the law for the last 25 years. But if one thinks about it, what's really happening here is there is science in public health, epidemiology, the study of disease in populations, toxicology, the study of how chemicals hurt living beings or animals. That science can easily be marshaled to explain why these people really do have the same problem, why there really is a common mechanism of their disease. But the courts have just said, no, you can't do that. If somebody is born with blue eyes to, parents from Iran, they're just different than someone with brown eyes from the United States. And we just can't, they might both have worked with asbestos for 30 years. And they might both have the identical disease called mesothelioma, which only comes from that chemical. But you can't do it as a class action. And that has rendered that tool, that powerful rule, kind of helpless in the area of public health. But there was an alternative raised in the 1980s in two cases called Ayers versus Jackson Township and Friends of All Children that said, let's look at people who have been exposed to chemicals but haven't gotten sick yet because of this latency period, because of the way chemicals work. And they developed a concept called medical monitoring. And what that theory said is, let's take these communities who have been exposed and at least give them medical attention. Give them preventive medical tests so we could either prevent their injuries or detect them early when we can do something to help them. That's called medical monitoring. And that's part of public health science. That's part of medical science. The courts have basically said you can't do that for groups. They've said you can do it for one person at a time who can bring a case, but you can't do it for groups. And the reasons are the same ones we talked about a moment ago. Everybody's disease process is different. So how can we figure out the cause of a group of people who have been exposed to a chemical and what tests they need if everybody is so different? So the courts have looked at it that way, and once again, they've kind of disabled the legal system from the benefit of the advances of science and toxicology and epidemiology to bring these cases. What's particularly galling about the medical monitoring result, and by the way, courts have also said that every state's laws relevant to medical monitoring are different, and we can't manage a group that has people from different states. But what's really galling about this is if medical monitoring would go forward, we would actually prevent some of these illnesses or catch them early when the damages could be mitigated or people could get proper medical treatment. The alternative is, if you don't get there early, you wait to the end. You wait till the mesothelioma victim dies from lung cancer, and then what happens? They bring a personal injury suit. And then what happens? One of two things happen. One is they get $100 million. One person with a disease gets $100 million. And the conservative critics think that's outrageous, and that a legal system that allows that is outrageous. Yet where were they when lawyers were asking for the testing early to try and mitigate? They were against that also. The other alternative to the $100 million for the asbestos victim is zero. Some of those victims with the identical disease will go to court and they will lose, just like we lost in Milwaukee. And so you kind of have this roulette system. When there was an alternative that could have got involved earlier and done something with a public health benefit, but the courts really have not allowed it. So just to kind of sum up on these two devices, the public nuisance doctrine is alive in some places. It's being used in opioids, it's being used in climate change, and it's certainly showing potential. I think the climate change litigation is really going to be critical. None of those cities have really gotten into the merits. They've been tied up through different legal rulings, and I think it's going to be very interesting to see if a city can proceed on a global public health threat using that doctrine. In the opioid setting, it's been used, and one other point about the class action rule, a never-before ruling was made a few months ago in the opioid litigation, certifying a negotiation class, not a personal injury class at the end, but saying that a group of cities could come together and form a group to negotiate on behalf of all the governmental entities who have opioid claims. So that is a positive development. And I should also say that the class action rule is allowed to be used by the courts to settle public health problems once both sides agree. So for example, in the NFL concussion litigation, once the lead plaintiff's lawyer and the NFL agreed that they wanted to create a fund and compensate the victims of head injuries, the courts allow that. But only when you have an agreement of both sides. You cannot go to court on personal injury in a class action if the defendant disagrees with the use of that mechanism. And that's about all I had on that topic. Yeah.
Thank you very much. That was great. Thank you. Really excellent. Thank you.